Hi, Bill Henshaw here again. Talk about some not so current events this time, but very important ones for the purposes of what I do and what I hope that you'll join me in doing. And that's a case called Ex Parte McCardle. Any of those of you out there, the viewers that happen to have heard about that case in 10th grade U.S. history or 11th grade civics, let me know. I wouldn't have known had I not done my own independent research. I would have never heard of William H. McCardle. All of us should have, because that case involved a situation where McCardle, who was a newspaper editor in Mississippi, wasn't too thrilled with what the federal government was doing during the Reconstruction period, and he was very plain about that in his editorials and speech and whatever, and he got himself in trouble and got convicted. I'm not sure he got convicted for treason, but he got convicted for criminal acts against the government and this, that, and the other by a military tribunal in the state of Mississippi. And the case reaches the Supreme Court, and it's a no-brainer. No-brainer. The term before it, Ex Parte Milligan, and you can look this up, 4 Wall 267, they ruled and set Milligan free when they just about had a rope around his neck in Indiana for doing pretty much the same thing. And his attorney said, not so fast. I guess that back in that era, sometimes they actually did their damn jobs. And he took a petition to the court, and the 904 in effect summarily reversed the conviction and said there was never a state of war in Indiana, hence the military tribunal did not have jurisdiction. End of case. The term before. Now you get McCardle coming up there making the same argument. But the problem he had is his stupid ass attorney used the Habeas Corpus Act of 1867. He should have known better. And what you're going to hear, by the way, from the comments in this case on both sides, is that the Habeas Corpus Act of 1867 did not give the Supreme Court any jurisdiction, so they couldn't hear the case. Nevertheless, they heard the case, decided the case, and were going to announce the decision 5-3 against the Reconstruction Act. And that on its face, without more, beats the 14th Amendment, which is all they think they have these days. That beats it. But the problem is that Habeas Corpus Act of 1867 was on the appellate side of the court, and in a rare slip up by the framers, they allow Congress to have power to control the appellate jurisdiction of the court. I would hope never imagining circumstances like this 75 years later. But they did, and the court passed an emergency act, and it must have been a hell of an emergency, and the court did not announce the opinion. Now, what I just said with the American case, all they would have had to do, one of two ways they could have got there. Say, okay, to the attorneys for McCardle, we're going to dismiss the case, refile it under the Judiciary Act of 1789, Article 14 and or 25. That they would have been able to hear, and the attorney on the government side conceded as much. Or they could have said, okay, what we're going to do is treat this petition as though it had been filed that way. And I think then and now they would have full discretion to do that in the interest of justice. Not just us, as I'm so fond of saying with dollar signs. They could have easily done that. But the problem is that the court got the message from the New York banksters, to not rule on any issues like that. And they dismissed it, and the case never got back there again. And this isn't the only example, by the way, in exactly the same time period. The case is called Cummings v. Missouri, 4 Wall 277. In the same time frame, next term, the court made a ruling on bills of attainder. That's the last serious decision they've ever made, 155 years ago. What the hell is wrong? Don't attorneys know what a bill of attainder is and know that's going to win almost every case, taking the property without judicial process? And all these bastards have are legislative tribunals? How does this not win? My fourth graders get this, for crying out loud. But it seems like a lot of law school graduates don't. And I think I maybe figured out one of the main reasons is probably all they concentrate on in law school is intimidation 101, treason 303,
Yeah.
and fornication 404. That's about all the bachelors are interested in. And we all know how good they are at fornication now, don't we? Um, but yeah, this is so simple. And yet you get, and I was really glad to see from David Dudley Field, and that won't be a recognizable name to most of you. I did know because he was most famed in the regular history books for having written the Dudley Code in 1872, the first standard code of laws in New York State. So that's somewhat more of a dubious distinction, but he was also a leading constitutional scholar of his day, a lot like Reverdy Johnson and Jeremiah S. Black. And in fact, Reverdy Johnson was on this McCardle case with him. And boy, what they did here, I mean, it looks like what I'm writing today 160 years later, and I thank them for having set this kind of a record here. So you get into this, and these are only excerpts, by the way, and I have not only this file that those of you can get complimentary with the request for information on my modestly priced constitutional defense document packets. You can find out about those. Send me an email at uwinandcourt@gmail.com, and I'll send you a complimentary copy of this document with excerpts from his argument. And when it's ready, I'll follow up because I have a copy that's not in Word format yet of the entirety of the oral argument that he gave in this case. Now, in that era, 1867, that was, of course, before Thomas Edison, so they had no way to record these things like we would do now. But this is a written record of the entirety of the speech. And in those days, people, you wouldn't have any way to know this, but in those days, oral arguments were a big social gathering in Washington, D.C., where the politicians came, took all their wives, and this, that, and the other. And oral arguments, in some cases, could take a couple of days. It's not like now. And no doubt this McCardle case was one of those. And you read the case, it's a 61-page document, the full document, with footnotes. Very valuable to read, understand, because if you get what Field is saying, and this was generally understood at the time, not like it is today. People, I mean, my God, you look at this and look at these dumbasses in defense counsel, they have no clue about any of this United States history. That's how damn bad the public mandatory school system is. You don't learn a damn thing. I didn't 50 years ago, and you almost certainly aren't doing it now either. They've got to get on with it here and get some real education in there. But let me read a couple of the comments of David Dudley Field. You're going to love this because, it says it like it is. And he opens up saying, my proposition is that a military government cannot be set up in the United States for any of the purposes mentioned in, and the reason is this: military government is prohibited by the Constitution. And he's right. Goes on, he says, no disputing the proposition that Congress may pass all laws necessary or proper for carrying into effect any of the express powers conferred upon each department of government. A lawful end, however, expressly authorized by the Constitution, cannot be obtained by prohibited means. What that means to you and me is, if the bastards in Congress have violated the Constitution, and they do it these days with every law they quote-unquote enact, a video for another day, but trust me, and we can't go in there, and every time I go in there with my documents, and Bill of Attainder leads the list, taking a property without judicial process, courts refuse to rule on it. They won't address it, the local dumbass won't oppose it. This is in what's supposed to be an adversarial government, where you have two sides arguing on what the issues are and what the law is, and you only got one of us arguing here. Who wins? Damn, how hard is this? But we can't do it, and we can't do it because now we have no judicial courts which recognize the Constitution, the states, and our citizenship. Once we get that back, the ball game is over for the people on Wall Street, and the hell with them. It's going to destroy the New York bankers. I'll be dancing the jig out there if I'm in any shape to do it, and get rid of these bums after at least 150 years. So it goes on. says, therefore, the choice of means for obtaining an end, however good, Congress cannot authorize the trial of any person not impressed with a military character, and they all think we're subject to that military jurisdiction's federal, regional, martial law rule, for any crime whatever, except by means of a grand jury first accusing and a trial jury afterwards deciding the accusation. This prohibition is fatal to the military government whenever, wherever, and under whatever circumstances attempted. Such a government cannot exist without military courts and military arrests and military trials. The military government currently in Mississippi would not last a day. And it wouldn't have then, and it shouldn't now. We're in the same situation. And the only difference between us and Moscow, Peking, and Pyongyang is we do a hell of a lot better job of concealing the truth from people who have the right to know it. If you understand all of this and you see where they're going, and you ask how, where is our voluntary, knowing, and intelligent waiver of rights? Not to mention consent of the governed. And to all you political bastards out there, no, you don't have the consent of the governed on Super Tuesday. Ain't. Not even close. God. So this goes on, and it says that any act of Congress which would annul the rights of states under the Constitution and permanently subject inhabitants to arbitrary power, that's going to sound familiar to a lot of you out there, would be an utterly unconstitutionally and void as a secession ordinance with which this atrocious rebellion commenced. In other words, they can't do any of it. This is 1867. What's changed 155 years later? Not a damn thing. People are going to argue the contrary, have to argue the 14th Amendment, and they don't want to get me in front of a jury asking them questions about that. Because I've got, when you get my materials, what you get with it, the full packet. And by the way, I note here, I'll send you information on the prices and things, but with the full packet, you save money because we don't charge PayPal fees for those. But with that full packet, among other things, you get an 82-page unopposed brief on admission of new states. And I've got, I think, 60 decisions of the 9 old farts in the U.S. Supreme Court. So contrary to what defense counsel in the Oakland case said, where we're sitting there interviewing the bastard, your interpretation of the law, this brief is anything but my interpretation of the law. And it beats them clean. No one has even attempted to answer this, not even in my South Carolina felony case. They didn't know what to do. And South Carolina, for those of you that don't know, it's the cradle of states' rights, for crying out loud. First state to secede, they had the nullification crisis there in the 1830s. I mean, these people should know better. They don't. I mean, my goodness. Get me started on that. In any case, this is the kind of thing that you learn and you understand what Field is talking about. And it helps you to immediately grasp the situation that we're in and how we got there. He couldn't have imagined what we're going through today, I don't think either. But he understood the dangers that would be happening here if this government was allowed to keep on like it was doing with Reconstruction. And unfortunately, it was. Well, a lot of things could have happened. The video's another day, and they really didn't get through with Reconstruction until, about 1877, 10 years later. And that's a very interesting election. And oh, by the way, the next video is not these, but I'm going to be talking about David Dudley Field again, who wrote a book about the election of 1876. You're going to love this one. If you don't know, it's Rutherford B. Hayes and Samuel J. Tilden, and Hayes beats him by one electoral vote under some bizarre circumstances. So, but which more later. In any case, remember to like my videos, tell your friends, subscribe, and see you next time. Thank you.